Andrew, good morning. Welcome to Drew's HQ.
Great to be here, Charles. Great to be here.
Can you just give our audience a quick intro of who you are?
Yeah, my name's Andrew Carter. I'm a barrister at 42BR, and I specialise in property and landlord and tenant law.
I'm Charles Grossman, Senior Associate here at Drew's, specialising in property litigation, both residential landlord and tenant, commercial landlord and tenant, and all types of real property work as well. But today we're focusing on the residential sector and the incoming Renters' Rights Bill, quite a radical piece of legislation. Do you want to just give us an up-to-date position where we are with it?
Yeah, so it's currently before the House of Lords in the committee stage, so we can see the broad outlines of the bill. It's of course subject to change, but we have a good idea about the direction of travel.
We know the gist of what's coming our way, really. We're just waiting for the final sign-off.
That's right.
So, in terms of the key changes for landlords, one is fixed-term tenancies are coming to an end. Because obviously, typically at the moment, a landlord grants a tenancy, it will usually be for around 12 months, but that no longer is going to be allowed, is it?
That's right. The key change is that there's going to be an end to fixed-term tenancies. So what that effectively means in practice is that each tenancy will be either 1 month or 1 week, and it will just continue on and continue on and continue on unless the landlord has a reason to bring it to an end, and that has to happen by a Section 8 notice. So typically, under the current regime, with the fixed term, you could bring it to an end by a Section 21 notice after the expiry of the fixed term, and the court would be bound to give you a possession order if you're a landlord.
Obviously, Section 21s are now coming to an end.
Yes, with the end of fixed terms, you won't be able to have a Section 21 notice, and so you'll have to have a reason or a ground for possession.
So one of the common ways of getting tenants out, not under the Section 21 regime, is through rent arrears.
That's right.
But the mandatory ground for rent arrears is being increased. Do you want to talk us through the changes?
Yeah, so currently you require 2 months of rent arrears in order to serve a Section 8 notice claiming rent arrears on a mandatory ground. That's now increasing to 3 months. So you need 3 months at the date of the notice and 3 months at the date of the hearing in order to get your mandatory ground.
So the issue with the current mandatory ground for rent arrears, which is 2 months, is that tenants would turn up at the hearing or the day before the hearing and just pay off the rent arrears to get it below the threshold. So now it's up to 3 months. It's making it even more difficult for landlords.
That's right.
So we're probably likely to see more reliance on the discretionary grounds. What do you think?
The discretionary grounds 10 and 11 remain unchanged. And so that's where some of the rent is unpaid, or the rent is paid late regularly. So I think we will see more reliance on those discretionary grounds. That of course means more risk for landlords, more uncertainty when it comes to court. But where you can't rely on your ground 8 as easily as you might have done, I think some landlords will be essentially funneled into those grounds, those discretionary grounds.
So it's imperative landlords get early advice if they are wanting to kick tenants out for rent arrears.
Absolutely.
Because as we've seen with the judgments with gas safety certificate cases, the judgments are so inconsistent. So when we're relying on the judiciary's discretion, as you said, there's huge risk. So taking early advice is key. So rent arrears isn't the only way of seeking possession. Landlords can also seek possession if they want to sell these properties, or if they want to actually move in and live in it themselves. Do you want to talk us through those grounds?
So ground 1 is changing. Ground 1 relates to occupying the property as your only principal home. Under the current regime, you had to give notice generally before the tenancy started that you might want to rely on ground 1. That's being done away with, so it's easier in some sense to rely on ground 1 now, or it will be if the bill passes. And it's not just that you require it as landlord, but some member of your family might require it as their only or principal home. So there's certainly an emphasis on ensuring that landlords or their families who require the property as a home are able to move back in. But of course, it's what the question is: do you actually require it? Do you actually intend to move in? That's an important.
Well, that's the key. That's the key phraseology in the bill here, because obviously it's similar to the Landlord and Tenant Act 1954,
yes.
which obviously governs the renewal of business tenancies.
Yes.
Commonly, landlords are relying on ground F, for example, for when they want to terminate business tenancies, whether they need to demonstrate a genuine intention for redevelopment purposes. And obviously, the same wording is being used in this bill, which is very interesting, because
yes.
in the commercial context, before they serve their Section 25 notice, similar to the eviction notice in these circumstances, the landlords will be expected to have submitted their planning application and really have an audit trail demonstrating their intention.
Yeah.
So it's going to be interesting to see what evidential requirements the judiciary will demand. But the answer to that question may well be in the bill itself and the marketing prohibition. Do you want to talk us through that?
Yeah. So the new Ground 1A provides for a mechanism for landlords who want to sell or intend to sell their properties to get mandatory possession orders with respect to those properties. In addition to that, the bill says that if you market the property or advertise it or tell someone that might be coming on the market for rent, then and you've got a 12-month period after the Section 8 notice or the claim form going in. If you market it in that time, you're committing a criminal offence. So it's really, really serious teeth behind that new mandatory ground with respect to sale.
So the point here is landlords that are thinking, oh, I'll try and sell the property, but if I can't, and get my tenant out, then I'll get another tenant back in. That's simply not going to be possible. And if they do that, they're going to have the local authority knocking. But also, it's not just landlords; it's agents, isn't it? Because they're going to be defined as a relevant person under the bill, aren't they?
Yeah. So agents are relevant people under the Act. They are subject of the same of some of the same prohibitions. And when it comes to marketing, there is a defence if they take all reasonable steps to avoid breaching. So, for example, if a new landlord comes to an agent saying, I've got a property that I want to put on the market, that agent, at a minimum, is going to have to satisfy themselves about how that property came to be on the market. Has it just come onto the market after a mandatory order for possessions come in? If so, then the agent might be on the hook.
This is a crucial point, isn't it? It's going to change the way that agents are doing their business, because when their landlord clients come to them now saying, can you market this property for me? They really need to make sure they're asking the right questions and they have an audit trail, because as we'll get onto in a minute, these offences under the Act have quite significant, like you said, they're criminal offences and they have quite significant fines. So what we're going to possibly see, as we've already seen in the sort of HMO context already, is local authorities imposing quite significant fines on both landlords and agents. The landlords and agents will then have an opportunity or a right to appeal, and then it will be kicked off to the first tier tribunal. And in that scenario, the landlords and agents will need to ensure that they're separately represented.
Yeah.
Because ordinarily agents won't necessarily need their own legal advice when they're letting out properties, and they'd rely on their landlord client solicitors. But I think a key piece of advice here for agents is you need to make sure you've got your own legal advice, because if it comes down to it, the landlord solicitors will be conflicted and they won't be able to represent them.
That's right, and you can easily see how an agent and a landlord might start blaming each other. The landlord may say, "Well, you didn't tell me that I wasn't able to let it out," and the agent says, "Well, you didn't tell me that it was that you'd only just got possession under Ground 1A." So it's very easy to see how a conflict could arise, and of course, proceedings in the first tier tribunal can be very expensive. Not to mention the fines that come down the line.
And we're going to be expecting a local authority to be finding using landlords and agents as examples to act as a deterrent. Because as we know, the local authorities' sort of MO is to publicise these offences So it acts as a deterrent. So they're going to be on the lookout in the first couple of years. So they need to be very careful, and they're covering themselves at all costs.
Yeah, and in terms of people thinking, well, it was only a minor breach, or it wasn't that bad. Those are precisely, in my experience, the cases that local authorities take up to make examples of the really serious breaches, or to scare the flock, as it were, and drive rogue landlords out of the market.
Marketing prohibition is obviously not the only offence. You want to talk us through some of the other offences?
Yeah, so there's some important financial penalties. These are not offences, but the financial penalties. So if you serve an incorrect Section 8 notice, which is a purported Section 8 notice, let's say you get the date wrong on the Section 8 notice, financial penalty. If you purport to terminate the tenancy by notice to quit, financial penalty. If you purport to let it out on an AST, let's say you send out the old precedent document by accident, and it gets signed, and and it proceeds, financial penalty. Even calling up the tenant and saying, yeah, the tenancy is coming to an end, that's a financial penalty, and $7,000 a pop, and suddenly you're looking at a serious consequence.
This is quite groundbreaking because ultimately typically agents would serve Section 21 notices on behalf of their landlord clients.
Yeah.
And in this scenario, if they make a mistake, they could be on the hook for a significant financial penalty.
Agree.
And also, you're mentioning there's a penalty for purporting to terminate a tenancy early. So agents need to be careful what they're saying to tenants.
Yeah.
Both on the phone and by email. So, again, it's why agents really do need their own legal advice to make sure anything that they're saying or doing or purporting to tenants doesn't expose themselves.
I agree.
Fine. So, obviously, we can't cover everything today in the limited time available, but those are the sort of real key headline points for both landlords and agents.
Certainly, as it relates to marketing, as it relates to rent arrears. I mean, it's no exaggeration to say that this bill will be transformative. It affects all sorts of issues. It affects rent repayment orders. It affects a range of matters we just haven't had time to touch on today.
So what would you say were the three main takeaways for landlords?
The most important one is that there are serious penalties for non-compliance with the new regime. That is going to mean that you need to take advice and make sure that you comply, because it will generally, because you're taking a risk that it will be economically not viable to continue on. But if you are thinking about getting out of the market, you need to have a genuine intention to get out of the market. And as we've been stressing, getting legal advice early is critical.
Yes, I think what we're saying, the takeaways for agents are, they are now relevant persons under the bill, so they are on the hook themselves.
Yeah.
They therefore need to be very, very careful when their landlord clients are approaching them.
Yep.
To market properties, ask the right questions, make sure you've got an audit trail, get your own legal advice as well, separately, and be separately represented from your landlord clients, because if for some reason the local authority are coming after you, you will need to make sure that you're separately represented.
Yeah.
And then I think the final point for agents who ordinarily will be the ones preparing the tenancy agreements for the tenants on behalf of their landlord clients is make sure that your precedent is up to date, because fixed term tenancies, as we said, are coming to an end.
That's right.
So it's, as we said, it's a really transformative piece of legislation. And what do you think are what's the significance of this piece of legislation?
Yeah, I think we will see tenants staying in the private rented sector for longer. They'll stay in their rented properties for longer. I think we're likely to see smaller time, say mum and dad landlords exiting the market. So it'll be interesting to see what effect that has.
And then the days of rogue landlords are probably going to be, or we hope to be, behind us.
Yeah, I think that's a key objective of the bill, is to get rid of rogue landlords, and hopefully we don't throw the baby out with the bathwater and get rid of the good landlords who make small mistakes but are generally good landlords.
Because, like we said, we're going to be expecting some publicised offences by the local authority, which is going to be acting as a deterrent. So hopefully the days of rogue landlords will be behind us. I think the final point to reflect on is how this is going to impact the property market generally moving forward, because we didn't touch on it earlier, but the bill does provide succession rights to tenants. So what that means is they can pass it to their children in their will. So if we get a family, in a comfortable, 3-4 bedroom house, rented, we can see it staying in the family for generations, 80, 90 years. So it's going to be interesting, because if we've got, good quality rental properties staying in families, why buy? So I think we're going to see a shift, ultimately, where, people are going to be less, obsessed with this idea of get first-time buyers and getting onto the property ladder, because, there's going to be a generation of renters, and it's going to be interesting to see how this impacts the wider development opportunities in the country. So, it's going to be very interesting, and, watch this space.
I couldn't agree more.
Well, thanks very much, Andrew.
Thanks
for coming in, and see you again soon.
See you soon.